On October 2020, the case of our favorite ex-commissioner, David Uible, came before the Ohio Elections Commission. It had to do with Mr. Uible mailing things out that he had paid for, but the disclaimer said the Republican Party was paying for him. He had good reason to do that since he was on probation from a prior crime involving petition fraud and wanted to make it look like he had real support and to play up his Republican Party endorsement. Hold on a second. Let's remember that. David Uible, a criminal on probation, was endorsed for Senate by the Claremont County Republican Party. He was represented by Aaron Moss before the Ohio Elections Commission. Aaron Moss fancied that he could have been prosecutor of Claremont County. Well, watch Aaron Moss make up some of the most ridiculous excuses that you could imagine for Mr. Uible's behavior in about 27 minutes of video that's going to be coming right after this intro. Let's, though, jump back and remember what happened. On April 7th, 2020, Greg Simpson, the chair of the Claremont County Republican Party, filed an offense report with the sheriff's office with a detective on behalf of the party. Look at the yellow highlighted part. He filed the report on behalf of the Claremont County Republican Party using their address, specifically around that there's somebody out there sending things out to try to make it look like the Republican Party is sending them out. In my view, the way that Greg Simpson reported the crime, he never wanted the crime to be solved. But the crime got solved, and the finger got pointed at David Uible with overwhelming evidence of David Uible's involvement and guilt in what was going on. But let's jump back to Aaron Moss. When the detective figures out Uible did it, the very people in the Republican Party that have been involved with, we got to solve this, Mr. Simpson coming forward and filing a report, they go into defend mode because they accidentally fingered one of their own swamp creatures, David Uible. So Greg Simpson was supposed to file an affidavit with the Ohio Elections Commission. Matters that come before the Ohio Elections Commission need to be filed as an affidavit from a citizen. But when Uible gets fingered, then all of a sudden Greg Simpson won't file the affidavit. Aaron Moss is part of telling him not to file the affidavit. Why? Aaron Moss is the vice chair of the Central Committee of the Republican Party. He's part of the operation. So Greg Simpson never files the affidavit. As a result, I end up filing the affidavit because somebody needed to file the affidavit so that the Election Commission could consider what Uible had did, which in the big scheme of life is a minor thing. And we'll talk about that a little more as we go on. Let's jump back, though, to December 9th, 2019. This is David Uible getting sentenced for tampering with records, a plea bargain on petition fraud. The judge there is swamp creature Richard Farrick, who still to this day on his judicial bio on the Claremont County Common Pleas Court site lists all his Republican accolades as part of his judicial bio. It is almost comical, and it must be that this guy can't even get an intervention from another judge. Hey, Mr. Farrick, judges are not supposed to be touting their political ideological affiliations on their judicial bios. You're supposed to be above that and not a damn clown. In the picture, you see Uible, and down in the little corner there, that is a special prosecutor from the AG's office named Joel King. He dealt with Uible and this prior stuff, and he got rolled. Judge Farrick protected Uible and didn't sentence him to anything. David Uible was on probation from this when he committed more crimes. The special prosecutor, Joel King, tried to get his probation revoked, and Judge Farrick just ignored it. Why? Because Uible's a made man. You do something small, you're going to get the book thrown at you in Claremont County. But if you're a made man, you better hope you get before one of your friends like that Farrick so that you know nothing's going to happen to you. But now the special prosecutor is back again. Our prosecutor, Ferris, ultimately recused himself from the new case after I bitched and moaned, and it ultimately got assigned back to the same special prosecutor who I hope has learned his lesson about how Claremont County justice works in the insider circle. Now back to the OEC. By the way, on this other stuff, there's other crimes. If you remember that Uible was charged with obstruction of official business and falsification, which are misdemeanors. Joel King, the special prosecutor, has now dropped those, and I think's working on something else. Okay. In fact, when you hear the video, you'll hear Phil Richter, about 2 minutes into the video, say, quote, There are also matters pending in Claremont County Common Pleas Court, or as it relates to this, or will be. There are also matters pending in Claremont County Common Pleas Court as it relates to this, or will be. He talked to Joel King, the special prosecutor. I think that David Uible is guilty of felonies relating to what he did with these mailings. And I know there's a 15-minute audio, because it's referenced in the detective report, that I think probably, if I were making a guess, I have no knowledge, but probably implicates Uible in destruction of evidence in an ongoing, tampering with evidence in an ongoing investigation. Now, for real, back to the OEC. So when the OECs have their hearing, you've got Aaron Moss now representing David Uible. Now remember, Aaron Moss is also an attorney in the Republican Party. Conflict of interest? No, not in Claremont County, no problemo. We'll represent whatever. We'll represent the defendant, you will represent the plaintiff, who cares? But Greg Simpson, actually, the guy who reported the crime, sends a letter to the Elections Commission defending Uible and attacking me. So Greg Simpson, the guy who reported the crime, then sends a letter defending Uible. And you'll hear that talked about during this 27-minute video as well. So we're about to hear it. We're about to hear Aaron Moss in his stellar defense of David Uible. Aaron Moss, he did this in the Painter thing, and he does it in this video. He keeps talking about wanting to basically put me on the stand or cross-examine me. And you know what? I keep telling him, I welcome that. I don't know what the rules are. I'll do it under oath. We can do it like a deposition. I would love for Aaron Moss to be questioning me. It would be comical. I think it'd make for great video. As long as we can video record it, I'd look forward to Aaron Moss questioning me. And when you see this and you see his attempted explanation and how quickly it's just totally dismissed by these people on the OEC, I think you'll really get it. All right, so there's going to be video, about 27 minutes. Enjoy the video, enjoy the defense, and know at the end that the OEC effectively found Mr. Uible guilty. They only gave him a $100 fine. I think that's egregious, and you'll hear me talk about this. But their policy is to only give a $100 fine on a first offense. And technically for Uible, this is his first offense at the actual campaign laws that this deals with. So let's jump in the video. Enjoy. Tell your friends to watch.
The next item on the working agenda on page 2 is Hicks versus Uible. This is a disclaimer complaint as well out of Claremont County. It too is a little bit different and interesting than what we normally deal with. Mr. Hicks is available online there. Counsel for Mr. Uible is present here. Chris is going to step aside and let him use his computer, I think, so that he would be able to address the commission as well. The issue here is that I guess you'd say a false disclaimer was placed on the literature because materials were circulated that reflected that they were the responsibility of the Claremont County Republican Party. But after a lengthy investigation by the Claremont County Sheriff, filed with this commission that that wasn't the party that was circulating these materials, but was circulated by a particular candidate, Mr. Uible. The investigation by the sheriff's office was conducted that confirmed that. There are also matters pending, I believe, in Claremont County Common Pleas Court as it relates to this, or that will be pending as it relates to this. We're really only dealing with the disclaimer issue. Certainly, we can hear from Mr. Hicks. We can hear from counsel from Mr. Uible as well. You can see my recommendation is to find the violation and impose a fine of $100. But Mr. Chair, if you want to hear from the parties to the matter, we have the ability to do so, or you can proceed forward.
I think since the parties are here, let's hear from them.
Okay. Mr. Hicks, it would be your basis to go first. You're the complainant. You're muted, Mr. Hicks. We can't hear you.
Okay, can you hear me now?
Yes.
Yeah.
Okay, Mr. Richter, I think you did a nice summary, but effectively what happened here is Mr. Uible represented that he had the authority of the Republican Party to a printer to print materials that were slate cards that were to help him. A backstory on the whole thing is one of the reasons why
I'm going to stop you there, Mr. Hicks, real quickly, just because I should have sworn you in to make a statement.
Okay.
And I didn't do so. I apologize. So, Mr. Hicks, we're going to do the whole truth and nothing but the truth to help you out.
Yes.
Okay. Thank you very much. Now, please make your statement. I apologize for interrupting you.
No worries, no worries. So I apologize for being on mute before. So what happened in this is Mr. Uible represented himself to a printer as having the authority of the Republican Party to send out materials that were favorable to him. The reason why, one of the backstory's motivations for that is that he was on probation at the time for a prior criminal conviction relating to tampering with a petition, where he had been, so he was getting hammered on that issue because he was on probation while running for the Senate. So he was then charged, as Mr. Richter mentioned, after an investigation with falsification and obstruction. And those charges just recently were dismissed only because the matter got moved to a special prosecutor versus an in-house cooking thing in Claremont County. And I believe that it'll be imminent that felony charges may be filed against Mr. Uible at some point. I think I heard that, I know your authority of what you do as a commission is limited in scope and doesn't involve all the things I just brought. But when I just heard $200 as a fine for a disclaimer, and I just heard Mr. Richter say a $100 fine for something like this, I think whatever the maximum penalty you can have is what should be being considered here. And I think it would be outrageous otherwise when there's criminal activity involved in falsified mailers that are taking place. So I don't know if I take questions, but that is effectively my statement. But again, I think that it would be irresponsible on part of the commission not to basically throw the book at this one when it involves criminal matters that are pending or will shortly be pending.
Are there any questions of Mr. Hicks from commission members?
Phil, try that again. You were garbled.
Oh, sorry. I kind of leaned away. I was just saying, are there any questions for Mr. Hicks? If not, you can hear counsel Mr. Uible. Please go ahead.
Thank you. Thank you for the opportunity to address this board. Mr. Uible would have been here personally present. He had sent some correspondence. He has had a scheduled trip to Idaho, and he is in Idaho and wanted to make sure the board, the committee knew how important this was for him. And I am here to represent Mr. Uible. My name is Aaron Moss. And what I completely disagree with Mr. Hicks' representation is that this was an unauthorized act. In part of your correspondence, Mr. Greg Simpson, the chairman of the Claremont County Republican Party, submitted in anticipation of this hearing a letter to this body. And Mr. Uible was represented by Mr. Hicks as not authorized. Our endorsement policy in Claremont County Republican Party allows an endorsed candidate, which Mr. Uible was, an endorsed candidate from Claremont County Republican Party, to the resources of the party. The slate card that is the subject of Mr. Hicks representing that he has somehow fraudulently used it is incorrect. The slate card that Mr. Uible had contracted for the reproduction of the slate card for him to send out was an endorsed slate card that was true in form as it was created by the Claremont County Republican Party. The Claremont County Republican Party, after they go through an endorsement meeting, creates a sample ballot. I refer to as a slate card sample ballot. The act here is that Mr. Uible reproduced the slate card in anticipation of mailing it, and it would have came from the Claremont County Republican Party, even though Mr. Uible was the person bearing the cost of the reproduction and distribution of an otherwise approved slate card. So my question is, when 3517 does include the print, distribution, reproduction, distribution, all must have the who paid for disclaimer, this particular slate card did have the paid for by Claremont County Republican Party. Chairman Greg Simpson, I believe that was also provided by Mr. Hicks in your materials. So the materials did have a disclaimer, but it was Mr. Uible who was actually sending it out. The other matters that are sensational and inflammatory about an unrelated part petition Board of Elections issue makes this more sensational than it really is. It's, you know, and by the way, that Mr. Hicks, I have no knowledge, and I don't know what knowledge Mr. Hicks has about some anticipated short order new felonies coming, but that unrelated charge, or that, well, this charge with falsification unrelated to 35-17-20, there's some other issues Mr. Uible's facing. But as we stand right now, that is a Nolly case. That is a 2020 CRB 01270 out of the Claremont County Municipal Court, and the special prosecutor out of the AG's office that nollied that case was Mr. Joel King. That was not an in-county prosecutor decision to nolly that case. I think Mr. Hicks used a home cooked or something reference to that. That's inaccurate. This was already an AG that put that nolly on in 2020 CRB 01270. And I really think that's peripheral to these hearings. The only notice that we have is 35-17-20. So those aren't an issue for this committee, but I just wanted to comment on them since Mr. Hicks brought that up in a way to make it sound like he has some knowledge that Mr. Uible is going to be indicted tomorrow or something. I have no information that if that happens, it happens, but all I can tell you right now is that it's nollied as we stand here today. So what I think you have is an authorized act for Mr. Uible to use the sample ballot as an endorsed candidate, and he was reproducing and sending it an otherwise approved sample ballot. We're asking the committee to make a no finding.
Thank you, Mr. Moss. Are there any questions from the commission? Whoa, hold on. I am muted now. Yeah. Come on. There we go. Are there any questions of the commission members, Mr. Moss?
Yeah, I have one. I'd like to know why in some of the material, or in the material we were provided, there was a copy of a letter from Mr. Greg Simpson, who was the chairman of the Republican Party in Claremont County. And he stated he filed a complaint that someone sent out cards with his name on it, which they did not send, which I guess they mean the Claremont Republican Party. Is that true?
Well, we got what I can speak to is I had 2 or 3 conversations with Mr. Simpson, as I recall, when this was all developing I can't remember whether it was February or March. But anyway, I had conversations with Mr. Simpson. I had more than 3 conversations with personnel from the sheriff's office as this was all ongoing about this matter, about who was responsible for these materials. And I more or less just kind of talked about what our role is, filing a petition, the application 35-17-20, and those kinds of issues. And if you would to read some of the materials, I think the sheriff's office, after I talked to them about our role and how we participate in the system, I believe in reading some of those materials, they reflected to Mr. Simpson wanted to file a complaint. It's appropriate to bring the commission to do that. We never received a complaint from Mr. Simpson related to these circumstances. Like I said, although I talked to him on numerous occasions, subsequently we did receive this complaint from Mr. Hicks, which raised these issues. We received a response from Mr. Uible, which you were circulated. We also received that letter from Mr. Simpson. I presume he felt obligated, or he felt it necessary to submit that letter on behalf, I guess you'd say on behalf of Mr. Uible, because Mr. Uible was a candidate, endorsed candidate for the Republican Party, and he explained the circumstances from his perspective as chairman of the Republican Party. As it was a part of our file, I circulated it to all of you for you to take however you wished to take it. So that's how we came into possession of that letter. That's how it was circulated to you, along with the complaint and the response in this case. I don't know that I've got a whole lot else I can add aside from that, but that's why you got those materials, and that's what came from. Mr. Chair, members, do you want to hear a comment from Mr. Hicks?
Sure.
Okay.
Can you hear me again? I didn't mute myself.
Yes.
So just in quick response to Mr. Moss, I guess you guys could continue this case and we could see what happens with other charges. But the fact that Mr. Uible was on probation was his motivation in trying to create pieces that appeared to be that he had support from other places. So by doing this with these cards, Mr. Moss already admitted it was Uible that paid for the cards, but the disclaimer said that the party did. Mr. Simpson's actually the one that filed the complaint with the sheriff's office, but in a way that was meant home cooking, that created a situation where they didn't think they would ever figure out who did it. When the sheriff's detective actually figured out who did it, then suddenly Mr. Simpson wouldn't file the affidavit that the sheriff's office asked him to, and came to me because I had been a witness in that with the sheriff's office to get me to file the affidavit that you guys received, because Mr. Simpson refused to do so to protect Uible after the fact. If there's any question relating to any of this, or if there's an option for you guys to continue it and see what happens with charges and other things, then I would recommend that you do that rather than make any decision now based on what I think is spurious information being provided by Mr. Moss as to what's actually gone on here.
May I comment?
Please, go ahead.
Well, first, the representation, the party bore the expense of the original creation of that sample ballot. That sample ballot was created after the endorsement meeting. Mr. Uible reproduced it at his own cost. He did not bear the original cost of creating that political literature. That was a Claremont County Republican Party cost. What spurious comments I'm making, I would like to know, because I think that I'm accurate. Do you disagree? I mean, not my opportunity to cross-examine Mr. Hicks, but do you disagree that the party paid for the original production of that material? If I could direct a question, Mr. Hicks.
I don't think that's appropriate.
Okay, I apologize.
I think that we lost Ms. Tavares. I don't know if.
Yeah, but I think
I'm back.
Oh, she's back.
Yeah.
I was trying to get on my computer. It didn't work.
Okay.
Let me just pose for thought a question. If Mr. Uible wasn't a candidate and he was John Smith in his living room, received some campaign literature, and he really likes that candidate, and at his own cost, he reproduces literature that says at the bottom, paid for by candidate, make up a name, candidate Smith, and he reproduces at that citizen's cost. Is that a distinguishing feature for us to consider? And this electronic day and age, if my Claremont GOP puts on the website a sample ballot, and I take the sample ballot, download it in the PDF and reproduce it. Now that sample ballot's going to say at the bottom, paid for by the Claremont County Republican Party. I'm reproducing that at my own cost. Is that a 35-17-20 violation? Because after all the sensationalism surrounding this, collateral matters to Dave Uible, at the fundamental basis of what I believe this committee is considering is the reproduction of a sample ballot that has paid for by Claremont County Republican Party, and in this particular case, it's being reproduced by a candidate, David Uible.
Who was not a private citizen, was a candidate for office that has to do campaign finance filings and so forth involved with this. So these just ridiculous arguments. If you guys can do it, I would just continue it and let the special prosecutor. The special prosecutor only recently became involved in this because it was being handled in-house in Claremont County. And you can hear from Mr. Moss the way things kind of work in Claremont County, where it's these ridiculous explanations. He reproduced something and he paid for it, but what if he was a private individual versus a candidate? Just continue it and let the special prosecutor do his work. The notion of Mr. Moss saying the special prosecutor dismissed the case as a nully, Mr. Moss knows the reason the special prosecutor did that is he wants to get the charges right, because the in-house charges in Claremont County were rigged to protect Mr. Uible. So just continue the matter and let it play out a little bit, so these cases that Mr. Moss are making can be borne out by what actually happens in the next month or so.
Gentlemen, hold on. I appreciate what you're talking about, what's going on as it relates to a criminal matter that may or may not be pending, etc. The commission members are welcome to disagree with me, but that is not relevant to, at least to me, that's not relevant to the case that we have before us that relates to these materials and the circumstances surrounding these materials. What the special prosecutor may do is up to the special prosecutor. While it certainly may involve these materials, it isn't an application of 351720. That's the responsibility of this commission. And so, if the commission would like to hear any further, certainly they would be welcome to step in and say, yes, I can hear further. But at this point, I think we've heard enough about that matter.
I agree, Phil. I think we've heard enough also. I just want to recap this. I think the issue before the commission is whether or not the disclaimer on this piece of information was proper or improper. And that's what's before us. I don't think there's any dispute in the fact that Mr. Uible was the endorsed candidate by the Claremont Republican Party. However, there's also no dispute that he put this piece of literature out on his own without the knowledge of the Claremont Republican Party. And therefore, I think your recommendation, Phil, of finding a violation occurred and assessing a $100 fine is appropriate. And I would ask the commission members, do you have any other comments to be made on this case?
And Mr. Chairman, this is Commissioner Kreitz. Hey, Phil, I've got a question for you. How did you arrive at the $100 fine?
This is the first time that Mr. Uible has been before this commission. There is a disclaimer on the materials. It's my belief that Mr. Uible's disclaimer should be on there as well, because it is he who paid for the circulation of these materials. And so while I appreciate Mr. Hicks is saying, I appreciate what Mr. Moss is saying, taking all the circumstances in the case under consideration as it relates to what this commission does. And again, looking at if there, as we have been discussing over the recent meetings, we'll discuss in future meetings, the commission's longstanding rule was for someone before the commission for the first time, violation of good cause, especially for a case like this, and a case really of first impression in terms of disclaimer present, but yet not who's responsible for the exact circumstances of this particular mailing. A good cause would have been at least in the ballpark previously. But as I assessed all the circumstances in this case, my belief we had with all of what occurred here in terms of party not being aware of the circulation, I don't know if I want to say attempted cover-up, but at least the situation where not everybody was willing to be straightforward in terms of, who was responsible for these materials. The fact that the person that actually paid for the reproduction and circulation of these materials didn't put his disclaimer on it. As I took all those factors into consideration, I thought that a fine was appropriate, but yet because it's the first time before this commission, and that we have the ability to only impose, a maximum fine of $500 is nothing to shake a stick at. But I felt $100 was appropriate. The commission, after hearing all the complainant and the counsel for the respondent, and after hearing my recommendation, wants to go in a different direction, I'm certainly not going to throw a lot of arguments in terms of, what should happen or, whether I think it's appropriate. I made my recommendation based on all the facts and circumstances that are present here, and what I believe is an appropriate penalty for what I view as a violation of the statute.
Any other comments from commission members? Hearing none, is there a motion?
Mr. Chair, I do have one more follow-up question. I apologize.
Okay.
Phil, a question for you is, I understand what we have to determine here is whether or not there's been a violation of Chapter 3517. The question I have is, what, if any, weight can be given to the fact that there's a sheriff's department, a sheriff's office report that's been attached to the affidavit that would suggest that there has been, I want to emphasize that there's been some deceit involved in this process. Is that something that we can give weight to? And if so, is that a reason to go ahead and delay this for a full hearing so we have an opportunity to consider that?
I certainly considered it as I went about making my recommendation. Yes, that along with all the various telephone calls in which I was involved as this matter was going forward, and my understanding of the facts and circumstances. So yeah, certainly I would not necessarily discourage taking that information into consideration. As it relates to continuing it, if that's what the commission wants to do and having a more full and complete hearing, again, those are the decisions that you all make. I merely make recommendations as it relates to what should happen. But considering the complaint, the response, the sheriff's report that we have before us, we could certainly continue it. I'm not, in my mind, I believe that there's sufficient evidence before us right at the moment to assert that there has been a violation of the statute. I'm not certain in my mind what additional information would be gleaned by continuing the matter and having a more full hearing at a later date. Certainly could do that. Like I said, you guys make the decisions as to what should be done under any circumstances. But as I view all the materials and circumstances here, I believe there's been a violation. There should be a penalty of some sort imposed. I don't believe that, to me, I don't believe that continuing this matter will aid in any way the situation. On the criminal side of this, I believe that it will go forward on the Title 29 violations, separate and distinct from whatever is done here. And I don't know that the 3517, the finding of a 3517 violation and imposition of a fine would impact what happens on the criminal side. That's my.
Any other commission members have any comments? Hearing none, is there a motion?
This is Charlita. I would move the recommendation of the executive director.
Is there a second? I second it.
Thank you. We have a motion and second to properly place this before the commission. I am to through a roll call just in case there is some sort of breakout here. And so each person will be asked individually. You either raise your hand or say aye if you would, please. Ms. Kaufman?
Before you do that, Phil, would you restate what your suggestion is that we're voting on?
My recommendation is that the commission find a violation of Revised Code Section 3517-21, which obligates a person responsible for materials to put their disclaimer on it. I think I said a violation, and impose a fine of $100 in that particular case. Ms. Kaufman?
Aye.
Ms. Cunningham?
Aye.
Mr. Kreitz?
Aye.
Ms. Tavares?
Aye.
Chair Broom.
Aye.
That motion passes unanimously.
Thank you very much.